Welcome to the Explainer. So, let's get right into it. What happens when a country, in the middle of a war, goes to the world's highest court and asks it to step in, and the court just says, no, we can't? Well, that's not a hypothetical. It actually happened back in 1999.
Yeah, 1999. This question wasn't just some academic debate. It was put to the test in the most dramatic way possible. You had this huge showdown between military force on one side and international law on the other.
So picture this. It's April 29th, 1999. Bombs are literally falling on Yugoslavia. And in this moment of crisis, they make this urgent appeal to the International Court of Justice. You probably know it as the World Court. They were asking for an emergency order to stop the bombing, targeting NATO countries like Spain.
But here's where it gets wild. The court's reply was stunning. They basically said they were powerless to act. They rejected their request. And that just leaves you thinking, wait, what? How on earth is it possible that the highest court on the planet couldn't even hear a case like this?
All right, so let's dig into how this all started. It began with that desperate plea from Yugoslavia, and the whole thing was set against a backdrop of what even the court itself called just immense human suffering.
You know, the judges weren't blind to what was happening. They absolutely acknowledged the human tragedy of it all right at the start of their order. But here's the crucial thing we're about to unpack. Being sympathetic to a situation is one thing. Having the legal power to do something about it is a totally different ballgame.
Okay, so this entire case, everything, it all boils down to one single critical legal concept. And it's one that a lot of people get wrong: jurisdiction. If you get this one idea, you'll understand exactly why the court did what it did.
So here's the thing about jurisdiction for the ICJ. It's not like your local court, right? A national court can force you to show up. The World Court can't. Its power is based entirely on one thing, and that's consent. The countries involved have to agree to be judged.
And I really can't stress this enough. This idea of consent, it's the absolute bedrock of the court's power. If that consent isn't there, the judge's hands are completely tied. It's that simple. No consent, no case.
So for Yugoslavia to even get its foot in the door, it had to prove that Spain had, at some point, agreed to be judged by the court. And they came prepared. They argued there were two different legal paths to prove that consent.
Now let's switch gears and look at Spain's side. For every argument Yugoslavia brought to the table, Spain had a really strong defense. Let's break down exactly how they picked apart Yugoslavia's case.
So Yugoslavia's first argument ran into a brick wall because of simple timing. Check this out. On April 26th, Yugoslavia says, okay, we accept the court's jurisdiction. Just 3 days later, they filed a case against Spain. But here's the catch. Spain had already filed a rule years earlier saying, essentially, we won't play if the other country just signed up. They need to have accepted the court's authority for at least a year. Well, 3 days is obviously not a year. So, boom, path number one was completely blocked.
Okay, so path one is a no-go. But Yugoslavia had a backup plan. Their second argument was based on the 1948 Genocide Convention. See, both countries had signed it. And there's a specific part, Article 9, that says any disputes about the convention should go to the ICJ. On the surface, that sounds pretty solid, right?
But Spain had an ace up its sleeve. A legal smoking gun, really. Turns out, when Spain signed that convention way back in 1968, it added a little note, a reservation. And that note basically said, we agree with this whole treaty except for Article I-9. They had specifically opted out of the exact part of the treaty that would have given the court jurisdiction. Just incredible.
So with both of those arguments shot down, the court's conclusion was, well, it was unavoidable. They said they manifestly lacked jurisdiction. That word manifestly is huge. It means it wasn't even a tough call. It was obvious. They had absolutely no legal grounds to hear the case.
But hold on, the story doesn't stop there. Because even though the final legal decision was crystal clear, behind the scenes, the judges themselves were having a massive debate. They were really torn up about what this decision meant, both morally and for the court itself.
Now, if you just look at the final vote, it seems like a total blowout, right? 14-2 against intervening. But that number is really misleading. It hides this incredibly deep and passionate debate that was happening among the judges about what the court's job should even be in a crisis like this.
Let's talk about those two judges who voted yes. One of them, Judge Shi, basically argued that, look, even if we don't have the legal power to order a stop, we're the World Court. We have a moral duty to say something. He thought they should have at least put out a general statement, a plea for peace.
And Judge Vereshchagin, he agreed and maybe even took it a step further. He called the court's silence unbecoming. Think about that word, He felt it was just plain wrong for the principal judicial body of the UN to stay silent while a war was raging. For him, the legal technicalities didn't excuse the silence.
And this is what makes it all so fascinating. It wasn't just those two. Other judges had their own, very different opinions. You had Judge Oda, who thought the whole case was inadmissible for totally different reasons. Then there was Judge Karoma, who felt the court had a positive obligation to help keep the peace. And get this, Judge Krela even questioned if the court was properly set up for the hearing in the first place. So many different angles.
So where does all this leave us? What's the big takeaway from this whole thing? What does this case really teach us about what international law can do, and maybe more importantly, what it can't do?
Well, in its final ruling, the court drew a really important line in the sand. They made it clear that, hey, just because we can't hear this specific case because of a jurisdiction issue, that does not mean anyone gets a free pass. Countries are still responsible for their actions under international law, period, whether they agree to show up in our courtroom or not.
And that, right there, is the bottom line. The ICJ isn't some kind of global police force with a world-sized arrest warrant. It's a court that runs on consent. Its power isn't about compulsion, it's about voluntary agreement. And if nations don't give that consent, even the World Court can't make them play along.
And so that leaves us with a really big and honestly pretty tough question. It was a central problem back in 1999, and it's just as relevant today. If the World Court relies on consent, who or what enforces the law when that consent is withheld?